This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about duty to defend and why killing two dogs on your property is an intentional act that is excluded, and that there is no duty to defend or indemnify intentional acts by an insured or to defend a person who is not an insured. Norma Hudson and Hudson Revocable Trust appealed from a summary judgment entered in favor of Farm Bureau Mutual Insurance Company of Arkansas, Inc. In the summary judgment order, the trial court found as a matter of law that Farm Bureau had no duty of defense or indemnification to the appellants arising from a lawsuit filed against the trust by Dewayne Evans, Mark White, and Billy Taylor. In the case Norma Hudson and Hudson Revocable Trust versus Farm Bureau, a October 5, 2022 decision of the Court of Appeal of Arkansas resolved the coverage dispute. Benjamin Hudson, Norma's adult grandson, shot and killed two coon dogs and allegedly traumatized a third on property owned by the trust. The dog owners sued Benjamin and the trust, raising claims for destruction of property, negligence, and the tort of outrage, and seeking compensatory and punitive damages. The allegations in the complaint against the trust were that Benjamin was employed to oversee the trust property, that he was acting in the scope of that authority, and that his outrageous conduct was ratified by the trust. Norma has two insurance policies with Farm Bureau. One policy is a homeowner's policy that insures the property where the shootings occurred, and the other is a property owner's policy. After the dog owners sued Norma and the trust, it made a claim, or they made a claim with Farm Bureau for coverage under the insurance policies. Farm Bureau subsequently sued, seeking a declaratory judgment that it owed no duty to defend or indemnify Benjamin, Norma, or the trust, based on exclusionary language in the policies relating to bodily injury or property damage arising out of intentional acts. The policies provided that Farm Bureau provided that there is no coverage for bodily injury or property damage caused intentionally by you or any covered person or at the direction of you or any covered person, and that the expected or unexpected results of such acts are not covered. Farm Bureau asserted that the dog owner's complaint alleged that Benjamin was acting as an agent of the trust when he shot the dogs. Farm Bureau argued that because an insurance policy expressly excluded liability coverage for damage arising out of an intentional act, it had no duty to defend or indemnify Norma or the trust, and that it should be granted summary judgment. The trial court agreed and entered an order granting Farm Bureau's summary judgment motion. Specifically, the trial court found: 1. Liability insurance coverage is expressly and unambiguously excluded under both the homeowner's policy and the property owner's policy for bodily injury or property damage arising out of the intentional conduct of an insured. 2. That it is alleged in the underlying lawsuit that Benjamin C. Hudson was acting on behalf of the Hudson Revocable Trust at the time of the subject incident, and it is undisputed in this matter that Benjamin C. Hudson acted intentionally in shooting the dogs in the course of the subject incident. And 3, that as a matter of Arkansas law, liability insurance coverage is excluded under the homeowner's policy and the property owner's policy from covering Dewayne Evans, Mac White, and Billy Taylor's alleged damages in the underlying lawsuit in relating to the dog shooting event. In its analysis, the Court of Appeal noted that once the moving party has established a prima facie entitlement to summary judgment, The opposing party must meet proof with proof and demonstrate the existence of a material issue of fact. On appellate review, the appellate court must determine if summary judgment was appropriate based on whether the evidentiary items presented by the moving party in support of the motion leave a material fact unanswered. The Court of Appeal views the evidence in the light most favorable to the party against whom the motion was filed, resolving all doubts and inferences against the moving party. The review focuses not only on the pleading, but also on the affidavits and other documents filed by the parties. Arkansas law regarding the construction of insurance contracts is well settled and requires the language in an insurance policy is to be construed in its plain, ordinary, and popular sense. If the language of the policy is unambiguous, the court will give effect to the plain language of the policy without resorting to the rules of construction. Once it is determined that coverage exists, it then must be determined whether the exclusionary language within the policy eliminates coverage. Exclusionary endorsements must adhere to the general requirements that the insurance terms must be expressed in clear and unambiguous language. If a provision is unambiguous and only one reasonable interpretation is possible, the court will give effect to the plain language of the policy without resorting to the rules of construction. The appellants state that the undisputed facts show that the insured Norma did not shoot the dogs, nor did she direct or encourage Benjamin to shoot the dogs. The appellants state it is implicit in the trial court's ruling that Benjamin was acting on behalf of the trust when the unrebutted evidence, the affidavits submitted by Norma and Benjamin, proved otherwise. The Court of Appeal disagreed and held that Farm Bureau was properly granted summary judgment. In the dog owner's complaint against Benjamin and the trust, they alleged that Benjamin intentionally shot the dogs while acting in the scope of authority to oversee trust property, and that his outrageous conduct was ratified by the trust. In reviewing the actual allegations in the complaint, the insurance policies unambiguously exclude coverage for bodily injury or property damage caused intentionally by you or any covered person or at the direction of you or any covered person. The duty to defend arises when there is a possibility that the damage falls within the policy coverage. Where there is no possibility that the damage alleged in the complaint may fall within the policy coverage, there would be no duty to defend. The Court of Appeal concluded that there is no possibility that the damage alleged in the complaint falls within the policy coverage, because if Benjamin acted at the direction of the trust as alleged in the dog owner's suit, the policy exclusion for committing an intentional act would apply and defeat coverage. Conversely, if Benjamin acted unilaterally and not on behalf of the trust, the Farm Bureau policy would not provide coverage because Benjamin was not an insured as defined in the policy. Therefore, the trial court's order of summary judgment was affirmed. In my opinion, the trust denied causation, claiming the shooter did not act for it. If he did act for the trust, there was no coverage because of the intentional act. If he did act for the trust, he was not an insured and there's no coverage. Intentionally killing 2 coon dogs could never be a covered event under any liability insurance policy, and it certainly was not an insured event under the 2 policies the trust had with Farm Bureau. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who asks by simply going to zelma.com/blog. And you can subscribe to the blog post so that you can receive blog postings every day as they are published. And you could also subscribe to the videos at rumble.com or youtube.com. And I'd appreciate if you do to click on the like button or the rumble button as you do. Thank you for your attention, and perhaps you might also like to subscribe to my Locals community and my Substack publications. Thank you for your attention.